the notion that judges or lawyers would be better at history than historians are is an odd notion to begin with. The right to privacy is something that has been recognized by the Supreme Court for many decades, even though the word privacy does not appear anywhere in the U.S. Constitution. Cases that revolved around the right to privacy all have the idea that in order to fulfill your right to life and liberty under the Constitution, there's a certain area of your life that should not have government interference in it. The important right to privacy case was in 1965. It was Griswold versus Connecticut, and it found that there was a constitutional right to contraception for married people. That snowballed into other related rights: contraception for unmarried people, contraception for teenagers, same-sex intimacy, the right eventually to same-sex marriage, and in the early years was the right to abortion. Even though in the Dobbs case, the majority kind of dismissed the idea that any of these other rights were at issue or were under threat, Justice Thomas, in his concurrence, actually says outright that he thinks these rights should be looked at again. And if you follow the legal reasoning about privacy not being explicitly in the Constitution, about abortion not being explicitly in the Constitution, and at least according to the majority not having a strong historical basis, I think people can rightfully say that there's at least a threat to some of those rights. The court in Dobbs based a lot of its opinion on what they said was deeply rooted in historical tradition. Actually, the court in Roe did the same thing, coming to the opposite decision, that deeply rooted in historic tradition was the right to or acceptance of abortion. I did not have a required course in history in law school. Most lawyers do not have to understand American history. There is very little, if any, history on the bar exam. So the notion that judges or lawyers would be better at history than historians are is an odd notion to begin with. History can be cherry-picked. History is not always clear. When the Constitution was enacted, slavery was still in existence in the U.S. There is no mention of the word woman anywhere in the U.S. Constitution, and the only time that sex is explicitly mentioned is the right of women to vote. Antibiotics, different kinds of medical care, different kinds of transportation. The challenge is to fit those new evolutionary technologies and new ways of knowledge into the general framework of the Constitution and the kinds of protections and liberty that it embodies. Another interesting area to watch, about which there will be a number of questions, is medical abortions. Medical abortions, of course, are abortions that are based on the regimen of pills. They can be taken at home. They do not involve, in most cases, any kind of surgical intervention, and so they make abortion easier and more private. The federal government, the Food and Drug Administration, has said that these pills are safe and effective, and they have taken the position that a state cannot ban those. There are going to be a lot of questions, though still legal questions to be worked out, when a state tries to ban them, when a state tries to ban them coming into their state, when a state tries to ban their being prescribed in that state. It's both a very promising area for broadening access to abortion, but also a very fraught area for ways to regulate it. One of the reasons that overturning Roe was so shocking to many was because it was a 5-4 vote. And in the very few times that the court has overturned other kinds of constitutional rights, they have been much more careful. So the example there is the Brown versus Board of Education decision, which overturned the notion that separate but equal is constitutional. And if you read any of the history of that, the court was very careful to come up with a decision that could be unanimous, because they understood that this is a change in the way the country is looking at basic rights. For the legitimacy of the court, they needed it to be unanimous. A 5-4 decision on something as major as this makes the court seem like just another political branch. The court talked about this being their way to get out of the space of abortion, to turn it over to the states, to turn it over to the people directly. But there are so many questions left up in the air, from the right to travel, to criminalizing abortion, all kinds of other medical health care, to contraception, to IVF, what happens with medical care and miscarriages, to what is the definition of abortion. It's very clear that the courts and the court are going to be just engulfed in this space for a very long time.